I'm going to eat my dinner while we talk.
I'll probably get up at some.
Oh, somehow or another we lost Judy. All right, so we are on, I think we're live now. We'll go ahead and get started. And I think Judy will be back with us. Corey, if you can watch for her and let her in, please, I'd appreciate it. Well, thank you all. Today is January 9th, 2024. This is our first Rules and Bylaws Committee meeting of the year. Happy New Year to everybody. I feel really good about the work that we accomplished last year. So we will, this will be like a good year for us, I think, now that we know what we're doing. We got all our stuff going on. All right, let me see. Let me share my screen. There we go. Oh, here she is in the waiting room. I got her coming in. Okay, so on the screen.
Are we
Yes, sir.
going to call the roll? And oh, you got it up there. Never mind.
Yes, yeah, I'm just going to start that right now. So here is the agenda. So I'll call the meeting to order. First thing we're going to do is take roll. Robert Baker,
Here.
Dottie Berger, he is absent. Matt Halterman,
Present.
Deb McCarthy,
Present.
Maria Russo says that she hates to miss it, but she's not going to be here tonight. Judy Stevens.
Here.
Selena Vickers, I'm here. Ray Whiting.
I am here.
Awesome. All right. And we do have a quorum. So can we just look over this agenda? And if anybody is willing to make a motion to approve the agenda, we can do that.
I'll take that motion, Selena.
Thank you. Somebody second it, please. All right. All in favor of approving the agenda as presented, please indicate by saying aye.
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 Any opposed? Thank you. Any opposed? All right. And so the meeting agenda is adopted. Let me make if I don't do this all at once, I forget. All right, so we got that. Now we're going to look at our minutes that went out today. From Dottie, if you could take a moment, if you haven't already looked over them, if you could take a moment to look over those. And whenever you're ready, I'll accept a motion to accept the minutes as presented.
So moved.
Is there a second?
Second.
All right. All in favor of adopting the minutes from 12/12/23 as presented, please indicate by saying aye.
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 Any opposed? Okay. The minutes are adopted. Let me change this. Awesome. All right. So next thing on our agenda, and really the only thing on our agenda tonight, is looking at the last time we were presented with, or we were asked to draft some rules of procedure for the Board of Appeals. And as you know, from our discussion last time, we looked at a few different types of rules of procedure, and then Bob took on the task of drafting that, and he used it's not exactly, but it's very, very similar to the process that the DNC uses. And so that's the basis of what we're looking at tonight. Bob, we'll go through this line by line, but what I'd like to do now is just sort of turn to you and let you sort of do, if you wouldn't care to do sort of an overall, you're the lawyer of the group. And so this is a very lawyerly type document and process, and that's for a reason. So I was wondering if you could just kind of take a few minutes and go over just generally what this is and sort of like how the flow of it works.
Well, generally, the idea is to create a process that's fair to all sides, with the decision-making being made by the Board of Review. The rules of procedure have probably the ones the DNC used, and I think it actually had to do with appeals from Alabama for uh, uh, issues with their state executive committee. But the idea is to create a system for starting a case, proceeding on a case, and finishing a case. So with each side being given the chance to say its piece basically and to appeal whatever a decision is from the Board of Appeals. Do you want me to go through the whole document or just that's the essential idea, is to make something that's fair for both the person who's complaining and the person who's complained about, so that they can present their positions to the Board of Appeals, either with or without oral testimony from witnesses, and get a fair decision that can be appealed further if necessary.
Okay. Yeah, why don't we go let's just take one section and you can kind of explain what that section does, and then we'll look at it. Several of us have been in and have made different comments, so we can
Sure.
address the
and-
different comments as we go through it. But yeah, let's do it that way.
And to the extent that there's language in here that doesn't make much sense or that seems to refer to something that doesn't exist, it's probably because I didn't do as good a job of adapting it from the DNC rules. But the first section is parties. Challenging party has to be a Democrat who resides in West Virginia. The challenged party has to be identified by in the challenge. And intervening parties, this allows the state executive committee to intervene in any challenge for the purpose of proceeding in any interest the state executive committee might have with respect to the proceeding. So essentially there's a complainant or a challenger, a respondent, or whoever was challenged, and the option for the state committee to be involved if they think it's important for the state committee.
Bob, one question that I didn't think of earlier, and I just now thought of it, is the DNC uses the term challenge as sort of like how we use grievance. And I'm wondering,
We could change it to grieving parties, and the grievance
Okay.
shall identify
Agreed.
okay,
who the grievance is filed against.
grieving parties.
No,
And
that should still be just, well, let's see.
okay,
Okay, grieving party, yeah, grieving parties. The grieving parties must be Democrats who reside in West Virginia.
okay. And then what would this say?
The challenged parties would be the aggrieved, wouldn't it?
It would be aggrieved, yeah, or let's see, I think responding might be a better term, though.
Okay. Is that okay, Judy?
Yeah.
Grievance.
And then could we call this, well, respondent or?
That should be the grievance shall identify the responding parties. I think that's
identify.
only important at this start anyway.
Okay, how's that?
Sounds good.
Okay. All right. Anybody else want to say
And then-
anything else? Go ahead.
In court, an intervener files a pleading to intervene, but I don't think it should be that formal for this.
Okay. Okay, well, I'm going to unhighlight that because I got highlighted early on. Okay. So, all right, so Mac had a note here that I thought this brought up like some good discussion, the intervening parties. So this is basically the state executive committee may intervene, not that they have to, but may intervene as a matter of right in any challenge, so that in any grievance proceeding for the purpose of protecting any interest of the state executive committee may have with respect to the proceeding. So,
You could add to that by sending a letter to that effect to the Board of Review.
okay.
Board of Appeals.
All right. So
Right after
yeah. So
proceeding.
he said how, and so this brings up a good point. You know, is if I'm a member, I don't think I can act on behalf of. I can't on my own make a decision for the state executive committee. Do you see what I'm saying? I think the chair of the party could,
Mm-hmm.
but
I can't read Mac's comment there.
oh, I'm sorry. So
If you slice
let
stuff to the
me,
left a
yeah,
little bit.
let's let Mac come on and just explain it because I'm not sure if
I
people
can
on
only,
YouTube can see it.
maybe I can move the,
Well, let's just let
I
Matt,
can,
can you come on and
I can
explain
see
your
it. Never
point?
mind. I can move people.
Well, yeah.
around.
For me, it was a procedural point. It's this idea of, okay, the committee as a whole, the executive committee has the idea to intervene or has the right to intervene. However, the question is how do they go about that process? Is it any one member of the assembly? Would the assembly have to hold a vote to intervene? And would that require a special meeting? We're working on very given timelines in this document. Of course, there are other options as far as, is it a majority member petition that we kind of do amongst ourselves? Does the chair do it on behalf of the members? If it's the chair on behalf, that raises questions of, well, checking that power or making sure it's enacted. That's why the initial question was just, how do we go about this process of intervening? Because there are so many avenues. And you said, yes, by sending a letter, but who is empowered to send that letter? And if it is just one person, how is that checked? Or if it is a group of people, how do we showcase that group's majority influence?
I think, my position, I guess, would be that it should be sent by the chair of the executive committee on behalf of the executive committee, and that the chair has the authority to act between meetings. I'm not exactly sure what our bylaws say about that, but I think that's, as a practical matter, what's happened is that the chair through the staff has acted between meetings, basically.
Okay, Selena can correct me if I'm wrong. However, the chair is also the person who appoints the members of the Board of Appeals, if I remember correctly.
Yes.
So that would make the chair his own check if we're talking about that powers wise.
Yeah, it ended up going to Corey, so it didn't. If it was just left up to the chair to make the decision, then it could be misconstrued in some cases as him being out to get somebody. So I think at least minimally they should have,
Or more likely to protect somebody.
yeah,
Mac,
it should be brought before all the officers.
Mac, correct me if I'm wrong, but don't the bylaws that we're proposing call for the members of the Board of Appeals to be elected by the committee?
Oh, I'm sorry, that
Appointed.
question to Mac, but it's
Well,
not.
the current proposal does not include that. I had written a proposal late last year that called for elections to the committee, but we have yet to move on that.
Yeah, we haven't moved. That's the direction I think that we're all going in. But these particular rules are for the current situation, which are appointed members.
Yeah, right, okay. Well, I guess the question is whether we create these rules to fit with the current circumstance or to anticipate what we hope will be the bylaws in the future.
I think these need to be just appropriate that we could just hand off to the current Board of Appeal because we can always make further recommendations, you know, as we need to. But I mean, I honestly, like, I don't really have an issue personally, and maybe somebody can provide, a different look at this, but this seems to me that, of late, there seems to be a lot of things that our chair, challenges that our chair has recused himself from because there's a conflict of interest. But I think that there are probably the typical challenge is something that would not involve that, you know what I mean? And so I don't think that I think that it's not out of the norm or to just have the chair act on behalf of the committee when they think that there's an interest, protecting the interest of the state executive committee. That doesn't mean that they have to. It just says that they may in some instances.
Well, I might also propose a way around this question. At the end of this, we discuss at the very end of the document, skipping ahead and spoiling it for everyone. There is a discussion on how the state executive committee could intervene after a decision has been made. Perhaps just expanding that right to they could also bring up a case that was dismissed as well, would solve this problem in the interim. I've made it clear that I am no fan of how this is set up. And if it was my doing, we would just be completely reworking this. But quite frankly, I am happy to compromise to these rules in the meantime. And I think that simple change would maybe we make it the chair now and just kind of move on for the sake of expediency and address the change at the end, empowering the state executive committee to take up any case that was brought before the Board of Appeals, even if they dismissed it. And that in the end would maybe uncork or put a cork in this problem.
I'm fine with that.
Yeah, I'm fine. So are you suggesting deleting the intervening parties paragraph?
No. Go ahead and leave it and just make it the chair. And then if it's abused by anyone, we just empower if the chair uses it in an abusive manner, we just empower the state executive committee to be able to take it up on their own. So the intervening party, the letter will be sent by the chair on behalf of all the members or on behalf of the state executive committee and just be done with it.
Okay, in
I
the
think it would
case,
go best at the end after the word proceeding.
I'm sorry, say that again, Bob.
I think it would go best by sending by letter of the chair or something. Whatever Max said. Just put
Well,
a comma after proceeding and add that language.
Well, I think he's suggesting putting it down at the end where he had those other comments so that we can kind of leave this part as is. But I don't think, I don't know that we necessarily have to I think it could be implicit.
Okay.
By that they send a letter or communicate to the Board of Appeals, don't you think?
Yeah, it just should if the full committee wants to intervene, they should send a letter to the Board of Appeals.
That was kind of the thing that I was, if you leave it to just one person to protest or contest
Well,
the
this is
action,
not so much contesting as it is saying we, the full committee, have an interest in the outcome of this grievance, and we would like to participate in the proceeding. It doesn't mean that they're on either side. They could have some different interest that seems to have been brought into issue by the grievance. Yeah, I think and the parties is good to
Okay.
all parties.
Okay. All right, well, let's move on. And then Mac, when we get down to that last part, let's discuss that part then.
Cool with that. Cool with that.
Okay. All right. So, all right. Bob, you want to talk about this section?
Okay, filing, creating the grievance in the first place, is what filing is all about. You create a grievance, you write a grievance. I think is there a way to do a global replace of challenge with
Yes.
grievance? How do you do that? I couldn't tell.
Okay. Okay, then we just have to make sure that the context is appropriate everywhere. So we'll just, as we go through,
We'll check it, yeah.
Yeah.
Could we just make a motion that the chair is empowered to make any clerical edits to this document as we have so
I'll
described?
second that motion.
Okay. Well, before we do that, let me just say my sort of thinking about this document is, and I'm open to your all's, ideas. I was thinking that we wouldn't necessarily vote on this document, that we just sort of have a consensus or where we stand with this document, and then we hand it off, because there's some things that like the staff needs to do, like figure out where is the best place to mail it and stuff like that, and which is the address that is going to go in here. So I think that staff needs to do a little bit of tweaking of this before it goes to the Board of Appeals, and that they will vote on it and adopt it themselves.
I didn't say we adopted. I just made a motion that you could make the necessary grammatical changes to it.
Well,
I seconded it.
okay, all right. Well, I heard that, but I was thinking we didn't need to do that level. But okay, all right. All in favor of the chair making changes, grammatical changes, say aye.
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 Any opposed? All right. Okay, sounds good.
Okay. Filing is the starting of the process, and this gives 4 different ways to start it. You have to prepare the grievance document, but it needs to be either overnight delivered to the executive director, or certified mail to the executive director, or electronic mail, that's email with delivery confirmation to the executive director, or hand delivered during business hours to the executive director. And then it gives either care of the State Democratic Party, and then P.O. Box 926 Charleston 25339, or 717 Lee Street, Charleston 25301, or some address at wvdemocrats.com. I originally had WV Party because for some reason in my contacts, that's what I had listed. I have a different contact for Ryan, but it shouldn't be Ryan's email address. And
I spoke to him briefly about this today, Bob,
good.
and he has the ability to come up with different things like Board of Appeals at WV Democrats or whatever. So but I think that's, whatever staffing email they want it to go to that is regularly checked, but they can come up with that.
This is going to him, currently him as executive director, functioning sort of like a circuit clerk.
Yes,
But it shouldn't have his personal email address. It should be an email address he checks all the time
exactly.
for the party. But I'm totally happy with leaving that up to him.
Okay.
Now, I had originally written this with a copy to the state party chair because I thought the chair should be in the loop. And
Yeah, I
Selena
struck that just
suggested
because,
taking it out, and I'm not quite sure what the thoughts are.
well, I just, you know, I think it only needs to go one place. And, if we're asking them to file with, I think that we either say you send it to the state executive or the executive director, or you send it to the chair. I don't know why we'd ask them to send to both. I just think we just need to send them to one. And I'm happy with it being the chair instead of the executive director. But I just think that it just needs to be one.
Okay. My thinking was that it should be somebody formal and that it would be good to copy the other, but that should not necessarily be.
Yeah, well, that's
And
fine.
I don't feel strongly about it at all. I just
I
put
don't
it in.
either. I was just trying to simplify for people, but no, there's
Yeah.
not an issue with that at all. I'll just take that out.
Max got his hand up.
Oh, I'm sorry, Max, and I've got this big screen up, so I can't see hands so well, so feel free to just jump in anytime.
I just didn't want to step on you. This is a question for Bob because didn't think of this while I was going through it earlier. Do you view this as primarily a legal process, or do you view this as primarily a political process? Because if it's more of a legal process, then I could see this going to the executive director. But if it's more of a political process, it might make sense to just make the state party chair the recipient.
I guess I see it as more of a legal process, and I was thinking from that perspective, that should be somewhat as much independent of the chair and the state committee as possible until and unless it's appealed to the state committee.
I agree with Bob.
Yeah, I agree with that interpretation. That's kind of why I can agree with Selena's logic to just leave the chair out of getting a copy for it. Because the assumption is whoever the executive director is, they'll verbally inform the chair that this is going on through their normal daily briefings, and this just becomes a legal process that falls on a non-political party until we decide that we have to intervene. If we have to intervene.
And it's true, like in a court situation, if you file a case in circuit court, there's no judge that gets a copy of it automatically from the parties. He gets they choose which judge has it, and they'll see it at some point when someone brings it before them. But so I'm happy with taking it out.
Yeah, I agree with that.
Okay.
If anyone has an objection to the contrary, feel free to step in. Don't let us railroad it.
This is not a railroading group, I don't think, but I hear your point. All right. So all
I'm thankful for that.
all grievances must be filed within 30 calendar days, leading to the grievance period. Okay. Okay, so I'm the one that struck this at, or in the event of a continuing violation within, but I was trying to simplify everything, and it just seemed to be implicit that they could file with any new violation within 30 days. I was just trying to take out stuff that we didn't absolutely need, but I'm not real wed to that.
I think it's something we don't absolutely need. I was just,
Okay.
I mean, all
right.
that doctrine is in law and it's not, there's no statute of limitations that talks about continuing violations. I think it's fine to leave it out.
Okay. All right. Service. You want to talk about what service is on lawyers?
Well, service is essentially giving notice to the responding party what in the world is going, that there's a grievance that's been filed and here's the contents of it. So it says that it shall be served upon all other parties to the proceeding. I think, and taking out the West Virginia State Party Chair because that's really not necessary. You're right. And then it tells how to serve it on the other parties, and it's essentially the same way as it's filed with the executive director.
So I struck this part. It's just about a certificate of service, but I read your comment, Bob. You think that it's important to have a certificate of service. I'm fine with that. I have a little personal issue with the very first challenge I ever filed with the DNC. I didn't know what a certificate of service was, and
Right. So that's
they dismissed it. I thought it meant, can I prove that I sent it? Which I did. I figured out a way to prove that I sent it, and I thought that's what it was. And they just dismissed. I mean, they dismissed everything just because I didn't have a certificate of service. So I'm not that.
okay.
But they're not hard
Maybe
to
we
do.
can make it easier.
I just don't want somebody's legitimate concerns to be dismissed because they don't have it. I think that they should be able, I think that everybody should be able to say, if somebody says, hey, I didn't get this, you filed this challenge or this grievance against me, and I didn't get a copy of it in a timely manner. I think that the person who said they sent it or was filing challenge should be able to prove somehow that they sent it. But I don't think that it should be able to be dismissed simply because somebody didn't send in a certificate of service. Does that make sense?
I understand. How about if we add language, failure to supply a certificate of service may be cured by the party who failed to.
Providing evidence of receipt or something like that.
It's whichever party didn't provide it. No, you wouldn't have to provide evidence. You could just add a certificate of service by providing a certificate of service. How about that?
Failure to supply. I thought that's what the beginning of it was.
Failure to
Failure
supply a
to supply a
certificate.
certificate of service may be cured by
providing a certificate of service.
At a later date or something.
Well, I don't care if they have a certificate of service. I think it's much more
What we
important.
care about is that people get it.
Yes, they proof of receipt.
But the certificate of service is someone certifying that they sent it.
Yeah,
which is normally in legal work, it's normally sufficient to establish a presumption that they received it. And if they didn't receive it, they'd be having to show that they didn't somehow, which is also tough.
But if they don't supply a certificate of service, wouldn't a cure be them being able to prove in another way that they sent it rather than just a certificate? Because all a certificate is them writing down, I sent this. It doesn't prove anything. So in other words, I could fill out a certificate of service. Yeah, I could send out do a certificate of service and say, I swear that I sent Bob a box of chocolates when I really didn't. It's really just my word against yours. But if I have if I paid, UPS to send it, I would have proof that I sent it to you. So if I don't send, if I have a certificate of service, if I include that, that's fine. But if I don't do my certificate of service, wouldn't a cure be being able to prove that I did send it somehow? Because all of the ways that we say that they have to service it are ways that have some type of receipt. So overnight delivery, signature required, certified mail, return receipt requested, electronic mail with delivery confirmation, or hand delivery with receipt. Every way that we've asked people to send these
What,
requires some kind of proof.
right, what, that's just for this initial filing as opposed to all others, but this applies to
true.
all documents. I
If
think
I could,
that,
Um,
if I could interject for a moment,
sure,
jumping to Robert for a second. Rule 6329 says that it is the duty of the officer acting as secretary at the trial to have on hand at the trial a photocopy, printout, or other direct reproduction of the letter of notification or any notification concerning the date, hour, and place of the trial with a delivery confirmation attached with proof that it was delivered. It doesn't call for a certification. For Robert, it just says that a delivery confirmation can act as that. We can raise that standard, but I did want to throw out that Robert addresses this issue and says that a delivery confirmation is enough.
what happens in law cases is that after the initial service, which does have to have some sort of record of it, the lawyers send back and forth pleadings, and they just certify that it was served, that it was sent. You can challenge that if you didn't get it, or you can write them and say, what happened here? And they'll say, I sent this. You'll say, I didn't get it. But, those are issues that can get resolved later. And what I was trying to adjust with this last language was to make clear that not having the certificate of service is not a gotcha, but in
okay.
fact it could be cured by providing a certificate of service.
Okay, understand what you're saying. If somebody didn't get it, can just make an issue of that they didn't get it.
Yeah, if they didn't get it, I mean, when you send something certified mail return receipt requested, you get both a receipt that you sent it, and you get the green card comes back to say they received it. That's
But in the case of the failure to provide a certificate of service, shouldn't we put a time stamp on that? Because you're only allowed 30 days to file a grievance.
right.
So,
Well,
I
that
mean,
would be a
if
grievance. That'd just be if somebody like the DNC sends it back to you and says dismiss, no certificate of service, you could send a certificate of service back to them. That's all this allows.
yeah, I mean, I'm talking about they need to do it, promptly to let you know they didn't receive it or whatever.
Well, the problem is that if they didn't receive it, they don't know they didn't receive it. It's only when somebody starts calling attention to the fact that they haven't acted or haven't responded, that they might realize that they didn't receive something.
Well,
Yes.
I think this is I think I misunderstood and I overthought. So I think this is a good. This would fix the issue that I had, and that was my big thing. Is I just want to
Yeah.
make sure that somebody doesn't get the whole thing thrown out because they, a little tiny thing. Okay. All right. Are we okay to move past filing and service? Okay. All right. So now we're down to time. Um,
I agree with Mac's
Yeah,
comment
I
that we
did
should
too.
just use calendar days.
we
But
should or shouldn't use calendar
we
days.
should use calendar days, but if
Yes.
the ending date falls on a weekend or federal or state holiday,
Mhm.
it should go to the next day,
Yeah.
the next
However,
business day.
any uh period of time ending on a weekend, federal or state holiday shall
Be extended to the next business day.
I like
I
that.
think
That
that should
way,
be a capital H on however, or else it has to, and that the stuff before needs to be.
yeah, you're right. Yeah.
Is that okay, Mac?
You left out at the very beginning, it says weekends, federal, and
Yeah,
holidays.
that
There
needs
should
to be
state in there.
deleted. That
Yeah, there should be a
weekends-
state right where you are.
Oh, I'll put federal. Let me put federal
weekends, federal and holidays shall
and
be included needs to be deleted.
state.
No, it needs to be deleted, that whole sentence. Right, Mac?
Yeah.
Okay,
No,
keep
hold
going.
on. No,
Delete, keep deleting.
keep deleting.
Wait. I don't think I can do it, right? See where my, you can't see my arrow.
Right here.
See,
Yeah.
see the sentence starting with weekends
Uh-huh.
Just get rid of
and
it.
ending with included?
Mm-hmm.
Just delete that.
We don't,
Yeah, delete
why
that.
are,
And
why are
leave-
we deleting that though?
You're not
Like, don't we
deleting
want,
however. Leave however. The sentence starting with however should stay in.
Yeah.
right, but don't we want people to, don't we want to be very, very clear that your weekends count, your holidays count? Like those are days that count. We're
Yeah.
just saying, hey, but if it ends on a holiday and UPS isn't running, we're going to give you an extra day.
Yeah.
Well, my original take was that exclude or that them counting is frivolous. I kind of worded it weird, but that's kind of what I was going for. Is I like Bob's just however any period ending on these days, it goes to the next business day. I think that's cleaner.
But when somebody is figuring out if they have 30 days, don't we want to be clear to them whether weekends count or holidays count as a day? I mean, I think they have a right to know. So otherwise they're calling up Ryan and saying, does Veteran Day count as a part of my 30 days?
That's fair.
And I understand the
I'm
problem.
fine with that then.
Yeah, I don't care either way, I guess. It's okay to leave it in. Weekends, federal and state holidays shall be included. And then all I can say is I just assume they're included, but a lot of people wouldn't, so you're right.
Okay. Okay. All right. So we're moving on to the actual grievances. All right. So, and the contents of the grievance.
Grievance.
Now,
That's
you,
grievance says as well.
yeah, you're right. I'm just, I was trying not to do too many of these like little corrections while we're on here, but I'll go back and do that. So here, you had asked, Bob, like what were these at the bottom? Here, I just put general rules. I think we just need somewhere, and I'm not exactly sure where they would go, where we say generally there's some things that you need to do all throughout. One of them is to have, I think they need to have numbered paragraphs. I think they need to have page numbers because, when you're reading if you're in a board meeting and, okay, you want to go to page
Yeah.
5 of the grievance, paragraph 7, it's just easier to find stuff. So having them send those things like that. Also, copies, I think it's very appropriate. We need to say copies can be sent electronically so people don't feel like they have to make 10 copies of whatever piece of paper. So anything that's sort of like a general rule, I was trying to throw down there rather than have something like this, like the grievance shall include the following in separately numbered paragraphs. Let me just take that part out. And we'll put those sort of general rules all together somewhere.
Okay. I was trying to figure out which generals you were talking about, but
Yeah, that
as
that was-
opposed to,
that was a quick thing. All right, so the grievance shall include the following. So the name, have to say, who the grieving
grieving party, yeah.
grieving parties are. And I just thought this was a little just a little very technical. And then the requirements of rule, 1A1 is basically that you have to be, a Democrat in West Virginia. So it was it's already stated, so I don't think we have to say that again. Again, I was
Okay.
just trying to simplify.
That's
Um,
fine.
And so this would be the responding party, right? Nobody's.
That should be, I think that should probably be in the party. Because nobody will know about it. Nobody will have an attorney or agent of record before that.
I'm not sure what you're saying,
I-
Bob.
Where it says telephone number of each responding party's attorney or agent of record,
Mm-hmm.
should probably just say telephone number of each responding party and delete everything after that, is what I'm thinking.
So you say you're suggesting to delete what?
Attorney.
Attorney or agent of record, if any, and also the apostrophe S in a party.
Oh,
And put a period at the end.
you wouldn't know who they are, is what you're saying.
Yeah,
At that point, no.
Gotcha. Okay. I understand that, what you're saying. Okay.
that's the problem of using a template to work from and doing it fast.
Yeah, that's okay. All right, so you and Mac brought up, this. So the state executive committee doesn't have a charter. We just have our bylaws. But I just put this like rules of the National Democratic Party just as sort of a very big umbrella for lots of documents, like, for the national charter, the national bylaws, the delegate selection rules, the call to the convention. There are different, just whenever there are.
So
Yeah.
Mac raised the question of whether there actually is a charter, which would be something filed with the Secretary of State, and I don't know the answer to that.
I've been a parliamentarian for over a decade. I've never worked with an organization that didn't have a charter. So if that is true, then I am completely blindsided by that. But I am also fine leaving it out because I agree with Selena's addition of just overarching language, because the charter, even though if there is a charter and it is issued in our name, it is actually still the charter of the national party. It's the party issuing a charter to create a subcharter. So it's their rules, actually.
It
So
could really
I
muddy the
think,
waters too.
yeah, I think as it's written with Selena's edits, I am perfectly fine with it. But I am amazed if it is true that we don't have a charter.
Yeah, and I'm
Well,
perfectly fine with how Selena has it too.
okay. Well, And I
I'm gonna,
mean, that's a really good question. Do we have, but I just thought that we had a national charter and that we are just under the national charter. So that the national charter is our charter. And we're just sort of a state affiliate of the Democratic Party, the National Democratic Party. So
Minnesota's Democratic Farm Labor Party would like to have a word with you in private, if that's the
Oh.
case.
yeah, well, okay, well, that's all I know.
Who we get a hold of? Ryan to find out, or Secretary of State?
I guess Secretary of State.
I'm looking now.
Yeah, either that or you would call the national party should have a copy if a charter was issued of it.
Yeah, they
I
would
would
have to have every
hope.
state.
All right, well, we're gonna go ahead and move on. We can figure this out. All right. So all right, so we have this, this is what they have to do in their grievance. So they have to have all the names of people. They have to have a statement of the alleged violation of whatever rules are being broken. They have to have specific statements of each allegation of fact. So they have to say, here are the facts. A specific statement of how the parties have and this will have to be changed to grieving. The grieving party has been injured by each violation. Statement of remedies that they've tried to do before they got here, and statement of relief requested, and basically the reason that they are requesting the relief. And then on top of that, you have to send in the following documents. Bob, do you agree with that the first one is redundant? We don't need it. A plain, concise, and specific statement that contains each violation alleged and each form of relief sought. I mean, I think that's sort of covered up in
Number of
here.
paragraphs.
Let
Yes.
me look up. Roll it back up a second. Okay, that's good. That's too far.
Okay.
Okay, you need to put ing next to grieve and ing next to respond in that A.
Okay, grieve, the ing
Okay,
is right
I see the
here.
ing now, challenge
And
separated.
then responding, yeah, it's in
That's the
there.
way it was deleted.
Yeah, sorry.
Are you saying D is redundant with?
So I think, see right here, 2A, a plain and concise specific statement that contains each violation alleged and each form of relief. It seems that the allocation of
Yeah, I
fact.
think that's covered in the one above.
Okay, all right.
The various
Okay.
ones.
All
So
right.
the D should get moved to the left somehow if you can, but
Which one?
the one at the start of the paragraph your cursor's on.
Oh yeah, well, right here, yeah. Let me.
See how
I'll format later. Yeah,
you can do that later.
yeah. Okay, so then that would make this A. So if we're okay striking that, then A, then basically the documents need to include basically a witness list, and any other documents that are offered in support, or a list of documents that will likely to be offered in
Yeah,
support.
so those should be A and B instead of.
Right. Yeah.
Yes.
Again, that's just a formatting thing I'll take care of. I'm just kind of
Yeah.
focused on content. Okay. All right. So does all that look good about what we're asking people to turn in for their grievance, the content of the grievance? Okay. All right. If you disagree, just speak out. Okay. So then the answer, and do we want to call it an answer, Bob, or do we want to call it a response?
I think we should call it a response.
Okay. Okay. Now I'll make the changes. Everything that right now says answer, I'll go in and make sure it says response. But
Okay.
so basically, I'm filing a grievance against Judy. Judy receives it. she has a certain amount of days to respond. What was in here is 10. I think that's kind of a short period of time because
I
the
agree.
person the person who sends the grievance, they know what they're doing and they have 30 days to put it together. What if Judy's mother is sick, or she's got crazy stuff going on at work, but she has this big grievance that she has filed against her, and she didn't want this, and she's only got really 10 days as the original, and then
Right.
now I changed it to 14. But now I'm thinking,
And
I think and maybe we should put in there that they can request more time or something like that. But, this can really come out of left field for some people.
Yeah,
in court cases, it's 20 days and you can get an extra 10 days just by saying you need it.
that sounds good to me.
So how many days so what do
20.
you guys want to
You
do?
could
20?
do 20 or 30 even.
Could we just do 21 with 10? That's 3 weeks and the option to make it
Yeah,
a
that's
month.
good. That's good.
Okay. And then how do we do how do we word the extra 10?
After
I would
service
just,
with the option of asking for extension of 10 days.
yeah, that sounds good.
Okay, how's that? And some of this grievance responding thing, I'll have to go back and change, but you get the
Yeah,
gist of that. Okay. All right. I like that. I think that gives them plenty of time to respond.
Yeah, all those grievance replacing challenge should be
Yeah, responded.
grieving party, but
Yeah.
you can do that.
that could be done like she did the grief.
Yeah.
Tidy up later.
So basically, we're asking them then to admit or deny each statement, or say that they don't have sufficient information to admit or deny. So they respond that way. And then if they have a defense, instead of just denying, if they have defense, and if they're alleged to have shot somebody on 5th Street and they were actually on 11th Street and they have proof of that, and they can say, here's my defense. I just took out I had to look up affirmative, Bob, and I just thought it
Yeah.
was just a technical thing. And is that okay to take out affirmative defense? Okay.
Yeah, I think that's okay.
Okay.
It'll just confuse people.
Affirmative as being not affirmative or whatever.
Okay. Okay. And then any other reason why they think that they should win the challenge. And then as far as documents, we're asking them to send in a statement that contains a response to each violation or alleged violation, request for relief.
I think that A is redundant with the earlier part.
Okay. Okay. to take it.
Just like it was above,
Okay,
and it can
and
be,
then this part right here, I didn't understand. Let me X this out so you can read it. I didn't
Yeah.
understand what this said.
yeah, I didn't understand what I wrote, so,
Okay, all right, we're just gonna strike that whole thing, okay?
yeah, just strike it and change everything else.
Okay, then we're gonna we're gonna have this, we got a witness list again, and we have,
What's that blue each of?
it was an accident. I was
Right.
probably trying to do too many things at once. Okay. And then a list of documents. Okay. All right. And then, all right, now
That
this
should
part
be
of it
responding instead of grieving there. And
right
3,
here.
no.
Oh, okay. Yeah, I see what you're
Start
saying.
of, maybe
Responding,
there too, I don't know.
responding parties. Yeah, I gotcha. Okay. I'll do a really good look at that to make sure I have this. All right. Now, Bob, I struck this and I forget why. Let me see. Oh, because it involved the staff, and I just didn't that we should involve the staff. Um,
Oh, the
and I,
executive director is sort of functioning as a clerk.
yeah, but we're asking them to do a summary of the challenge and recommendations. I just think that's too
I
much to
think
ask
that's
staff.
okay to take that out. for
Yeah.
sure.
The-
But the first sentence I think ought to stay in.
Okay.
That should probably be the chair of the Board of Appeals.
Yeah.
Okay. Upon receiving the challenge, the executive shall forward the challenge and the answer to the Board of Appeals for review.
Yeah,
And then we'll take out this part.
Yeah.
Okay.
yeah, I don't think we should be asking them.
Okay.
But he's
And
not
I would
part of
put
the,
chair of the Board of Appeals.
I'm sorry,
Or
what?
it could be Board of Appeals. I don't think the chair is who they communicate with anyway.
Okay. All right. So then we're down to dismissal and decision on the pleadings. And for some reason, this is C12. I'm not really sure how that happened, but no, that's a formatting thing. We'll get to it. Okay. So, okay. So you have the Board of Appeals has this grievance, and they can, so this is going to cover dismissal, situations where they can dismiss it, and then, whether they want to make a decision on the pleadings, which is basically making a decision without having a hearing. So look at the information that's sent to them rather than having a hearing. And then we're going to go talk about a hearing as well. But this part right here is just about that. So dismissal, we're saying that the Board of Appeals may, it doesn't say they have to, well, unless you're okay with, you guys, okay, Bob had shall dismiss. I think we should turn it to may and give them the opportunity, let them do whatever they want to. But I'm open to suggestions from you. I mean, I don't have my heart set on that. But basically, in these circumstances, they can just dismiss it and without having a hearing. Okay. One, it doesn't fall within the jurisdiction of the Board of Appeals. Two, it's brought forth by people who don't have standing to file the grievance. So let's say a Republican, you have to be a Democrat to have standing. A
And you have to
Republican
be from
brings
West Virginia.
and you have to be from West Virginia. Yeah. So let's say Mitch McConnell wants to file a grievance against us for somebody, that would be, you could just dismiss it. It fails to state a valid grievance. All right. That can be very, very subjective. The same grievance has been previously resolved. There's no evidence or support in the grievance. So it's just a bunch of allegations. There's actual no evidence of the thing that they're saying. There is an adequate remedy pursuant to state law or the rules available to them, which has not been exhausted. So if there was another method that they could go through before they got to the Board of Appeals, they should do that first. or the grievance is frivolous or dilatory, which is dilatory just as another word that basically means
Spiteful.
no, just time, just it's
Slowing it down.
Frivolous. The difference is frivolous is through naivete, dilatory is with malice.
Okay.
yeah, it's to me it's bad faith. You're doing something in bad faith. So are we, and I think this part is really important. We're basically saying, the Board of Appeals can just, based on this, they can look at it and they can say, this is dilatory, this doesn't have evidence, blah, 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 we're going to dismiss it. Are all these reasons, are we okay with all of this?
Yeah, provided the board follows them.
Yeah, well, it's going to be us to make sure we have a good board, which I think we have a good board now, but
Yeah. Well, the
Not
written
even.
opinion is what's important on that because it can be appealed.
okay. All right, so moving past dismissal, now we're on to the decision of the pleadings. So this basically says that the board has the authority to make a decision on the pleadings, which is, the stuff that has been sent in, where it's plain from the grievance and the response, together with the documents accompanying those, that there's no genuine issue of material fact between the parties. Any decision on the pleading shall be accompanied by a written opinion by the board. So basically, the board looks at everything and says, we're going to make a decision based on this information that we have in writing.
Yeah.
Now-
And essentially it would happen when everybody agrees on what happened, and it's just a question of interpreting the rules.
Mhm.
It's like a summary judgment motion for those who
Mhm.
have any legal experience.
All right, now let's talk about this next thing. I'm just gonna, I wanted to delete this because I just think it adds a complication, but I'm gonna X out my strike just so we can read it in case other people want to look at it. So basically, this says that if it's dismissed, or one of these two things happens, they make that summary judgment, the decision on the pleading, or they dismiss it within 5 days, then an aggrieved party, somebody can file a petition for review, stating what their objections are, blah, blah, blah. I, I just thought that added a level of complication to the whole process, because they already have the option of they can appeal to the state executive committee if they're anyway. Does that make sense?
It's redundant.
Yeah,
Or
I
is
think
it the process of appealing?
I'm pretty sure that this was in, I mean, I know this was in what the DNC had, but I think the reason was probably so that they could get quick review of a dismissal without a hearing. And so the question is whether you want that extra. I don't particularly care that they can go through the ordinary appeal process, but I think this was designed to, if it was wrongfully dismissed, to get it back on track quickly. That was probably the point of why they did it.
Okay, so the same 4 people that dismiss it, this is filed with the state executive committee, right?
Yeah. So, I don't know that it's needed. The regular appeal process might be quick enough. This is obviously very fast tracked, and I don't know that anybody could do it that quick.
Well, let me ask you this question. and this kind of speaks to what Mac, and he has a point about, well, how is the appeal process? And honestly, Mac, when I was like down at the bottom, I was reading that, I'm like, well, I mean, we're supposed to do rules of procedure for the Board of Appeals. You know, do we have the authority to say what the state executive, I mean, to write that, you know, because we weren't specifically asked that. But it does this right here, maybe what this is, instead of it just doing on dismissal or decision of the pleadings, it would also be the process. You know, let's just say that there was a hearing and they were appealing that. With this, could we use basically this process for it to get to the state executive committee?
I think at the end, we need to tell how an appeal is taken, but I think what the state executive committee does with it is something for the rules and for the bylaws.
I agree. I agree.
So I think it's, unless people feel it's important to have a quick review of, and it wouldn't necessarily be quick because the executive committee doesn't meet very often. A quick review of the decision when it's a dismissal without a hearing. Unless people think that's important, I think this should come out.
Well, in a situation like this, if you did keep that in there, that would require the state committee to meet because there's a time frame on it. So put them in the frying pan too.
Well, it doesn't.
Well, there's no
It
time
doesn't
frame
put
for
a
the
time
committee.
frame on the state committee. It just says that it shall be given precedent. Which in our rules would mean it would probably be made a special order and it would come up near the start of a meeting to guarantee that it got taken care of. But I mean, I'm
What
not
about the 30-day thing? See, that's,
well, 30 days for us to call a meeting, but
no, I mean, for the limit, 30-day limit on the appeal.
to file it doesn't mean it has to be heard within 30 days.
Right.
I'm not married to this. I'm very much in favor of checks, but I'm not married to this. I do think I don't know how this document is going to be used in the long run. So I do think it is important that we have the appeal process in this document. That's my opinion.
I think so too.
I'm just playing devil's advocate again.
No, that's fine. I like it. It's just I'm not married to this. I'm fine with it going just so we get an appeal, a language of how to appeal in this somewhere. That, I guess that's my qualifying statement.
Which
Well,
we have
why don't we
above, do
do
we not?
this? Why don't we put all this in? I'm gonna pick a pretty color for it. I'm gonna put pink, and let's move on. And when we get down to that part, let's have a fuller discussion about it and then decide if we want to use some of this language or parse it out a little bit differently. But I think we're all in agreement. We want there to be a strong process or a very clear process for appeal, but maybe it doesn't need to be two separate processes, you know, something here and then something if they lose, if somebody's unhappy with the results of a hearing, maybe that could just be one fell swoop of how to appeal.
Yeah.
Yeah, I'm
And
cool
maybe
with that.
Instead of
use
having
some
it
of this.
separated.
Right. Okay. All right. So now it's not dismissed and we did not make a decision on the pleadings, and now we're going to have a hearing. So this just means that there's a pre-hearing conference. The Board of Appeals will determine whether a factual hearing is necessary to determine things. They may call for pre-hearing conference of the parties. And at that conference, the Board of Appeals will do several things. So we'll make every reasonable effort to facilitate a settlement. With the parties, they will discuss the scope and procedures to be followed at the hearing. And they may request a final list of witnesses, a final list of documents, and a stipulation of the parties to any issue not in dispute, so that when they get into the hearing, they can go boom, boom, boom. These are the main things that we're trying to determine. I think that's all to like just keep the hearing on track so it doesn't get really, really tangential. So then, so they don't have to have a pre-hearing conference, but they may. The hearing itself, shall be held on specific factual and legal matters in dispute. There will be a recording made of the proceedings. If it's an in-person one, it will be in Charleston unless the Board of Appeals determines that in the interest of justice, it should be held elsewhere. And then it says, and maybe because we do so much with Zoom nowadays, and not that it has to be, but it may be held virtually as long as the public can view in real time. To me, that's the most important thing, is that,
Yeah.
the public be able to view. The hearing shall be conducted by the Board of Appeals.
Do you think we should let if any party objects to a virtual hearing, that they, whether parties could turn down a virtual hearing? Is there something, do you think we should have anything in there about that?
No.
I would argue against that.
Okay.
Me too.
It's too abusable, especially because you're going to have traditionally disenfranchised or impoverished communities likely bringing challenge. I would like a caveat added that it can be held virtually as long as the public can view it in real time, and that it can be publicly accessed after the meeting. I think that archival stipulation is important, having dealt with this situation with other groups in the past.
Okay.
Well, let me ask you this, Matt. Do you think it has to be publicly accessed all the time, or just that it has to be accessed upon request?
I mean, Nikki leans toward request. I think just put it on a YouTube channel and call it a day, to me, is less work and less effort on the organization as a whole. But I'm not married just so it is accessible after the meeting as well.
I'm anxious to hear what other people think. I see a positive and a negative to having the whole laundry, dirty laundry out on the internet all the time. But I do think that when people call up and say, I'd like to, I'd like to see the recording or have the transcript of the blah, 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 it should be made available. I mean, anybody should be able to have access to it. Other thoughts?
So make that access after the fact upon request.
Yeah, okay, let's just do that and move on. I'm not married either way to it. I just so it's accessible, I don't care.
Yeah, because if
I
it's
think
done
that
virtually, they're gonna have
access
to be able
should
to.
just be access, but sorry, Mac. I talked over you.
No, you talked over me, but that's okay.
Sorry, Judy.
It doesn't matter. It's not that important.
I was just looking at grammar about access and accessed in that last sentence.
Oh, did I have that misspelled wrong?
Can view in real time and access after the fact upon request.
Oh, okay. All right. All right. Prior to the start of the hearing, the Board of Appeals may, is that okay with you guys, to change from shall announce a ruling to may announce a ruling identifying the issues in dispute?
I
And the reason I mean, I just think it's some of the stuff that we're asking the board to do, and these are like a lot of lay people. We're lucky that we have, right, well, Teresa has been doing a lot of the last couple of them, and she's a lawyer. We have one other lawyer. But we have like regular people who we want regular people to be on this Board of Appeals, and I don't want it to be so complicated for them to be able to participate. And is it reasonable? Do they have to narrow it like before the hearing, narrow it down to all the like here are the specific things that were the issues in dispute? I don't know. I was trying to simplify.
I have a question.
ahead.
Why would, excuse me, why would they request people who are neither party nor witness to the proceedings testify? What would be the purpose?
Well,
Just,
I'll give you okay. Let me answer your question, then we'll go back to 4. An example of that, let's say there's a grievance about something that happened related to party registration, or could somebody vote, or could somebody go to a Mass County convention or something like that. And an expert on the issue might be the county clerk or somebody from the Secretary of State's office who like knows the state law. And your Board of Appeals, it might be nice to say, hey, before we get into this grievance, this is about some technical stuff with voter registration that we're not real familiar with. We'd like to call who knows the most about this. And then somebody says, oh, well, such and such that works at Secretary of State's office, or such and such that's a county clerk for 20 years. Why don't we bring them in and let's ask them some questions so we get our brain wrapped around this issue before we go into the hearing? That was sort of my thought, and especially some of the things that I've seen in different grievances are just really complicated issues that it would just be good to have a base of information about before people move into making, decisions.
like in a trial when they call in expert witnesses.
But in this case, the Board of Appeals can basically say, look, we want to learn about this issue before we get into it.
Okay.
So we want our own expert witnesses, not, to just give us some education. I look at it more as sort of like they can call in and say, look, I need some education on this.
Okay, gotcha.
Actually, Selena, you made a better point with that sentence than you thought you did, because whenever I read it, I was called back to a change we made with the treasurer. We use the term best practices in how the treasurer should operate the finances. And if you challenge the treasurer over whether or not they were adhering to best practices, and you can't call outside witnesses, the treasurer is the expert, and they are always going to say that their practices were best practices. So I actually thought that was a very ingenious ad, because it allows them to tap in cases of expert dispute. So I gave you a lot of credit there.
I'll take it where I can get it. All right. Okay, well, let's go back up to 4 just for a minute. I don't know, maybe I shouldn't have like struck some of this stuff out. The Board of Appeals shall have the power to rule that on certain issues only documentary evidence shall receive. Again, I was just trying to simplify it, but I'm not married to any of that. Do you have a preference one or the other, Bob?
I'm sorry.
On 4, on the strikeout, are you okay with the strikeout?
I think I'm not, but I don't think it makes a lot of difference. So
That's
I
fine. I
would
mean,
do
I'm
whatever.
not married to it. I was just,
It was essentially a proffer would be if they say they're only going to accept documentary evidence, then a person who wanted to put on witnesses could proffer or tell the Board of Appeals what the witness would have said if they'd testified.
Yeah, I was just thinking that I think they have I think the board has the authority to do that anyway, but let's just leave it. We're good. Okay. So are you guys okay? It sounds like folks are okay with, saying that the board can call in their own people to get information. Okay. I don't see everybody, but I see a head nodded. Okay, so the Board of Appeals shall hear the evidence, dispose of procedural requests and similar matters to the extent possible, obtain stipulations of the parties as to the facts of the challenge. So that's basically their job. Shall have authority to receive all competent evidence and to assign it appropriate weight. They will have the authority for good cause. I'm not, Bob, I didn't really understand this sentence. I tried to add commas to make it work, but I think that didn't work. Tell me what you're trying to say with this sentence right here.
Board of Appeals shall have the authority to order for good cause that a party produces at the hearing designated evidence in the interest of justice. I don't know that the commas add anything.
Say that sentence a different way so that I'll understand it.
The Board of Appeals shall have authority to order for good cause that a party produces at the hearing designated evidence in the interest of justice. In other words, they could tell them to produce something like a contract if there's a contract involved. But it'd have to be specified what they're being required to produce.
Okay, so can we take out for good cause?
So I have the authority to order the party produce. Yeah, you could take that out and the comma after it.
Okay, so the Board of Appeals shall have authority to order that a party produces.
At the hearing, and then a comma makes sense, I
So
think.
let's put this here. The designated evidence in the interest of justice at the hearing.
Okay. It's fine with me.
Okay, does that make more sense? Or maybe not more sense, but just is a little bit clearer about where a party produces designated in the interest of justice at the hearing.
I think either way is fine, and you can decide as far as I'm concerned.
Okay.
And the comment about me ought to come out, yeah.
Bob. Okay. And I love this where a party fails to produce the evidence. So if the board says, hey, look, you claim A, so produce some evidence of A. And if they fail to produce evidence of A, then that just simply because they don't provide the evidence, then this says that the board can find against them, right?
Right. If they say we had a contract and the Board of Appeals says produce the contract, they don't produce the contract, and the board could say that there was no contract.
Gotcha. Okay. I really like that.
Yeah, it's a he said, she said.
Mm-hmm. All right. And so subject to any ruling, each under blah, 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 each party shall have
Better
the
check
right.
that 3F4 is what it was when that was written.
Yeah, I will. Each party shall have the right to present competent oral and documentary evidence related to specific matters at issue and to conduct cross-examination. And we're not putting a timeline on this. There's sort of an assumption that the chair will be fair in allocating time to witnesses and cross-examination.
Yeah, telling somebody they have 3 minutes or whatever, you can't, nah.
I agree. The Board of Appeals may require parties to consolidate their grievance or challenges for defenses purposes of the hearing. That kind of makes sense. After the conclusion of the hearing, the board may set a briefing schedule for the parties. Now, I'll be honest, I kind of got hung up a lot on this part of it because it's really important to me and Democratic Party rules that decisions are made in public. I think most I mean, we know it doesn't happen, but most deliberation needs to happen in public, right? Like people need to know how people got there. Um, I'm assuming, and tell me what you think, Bob, that 9 out of 10 of these of a hearing, if you have a hearing, 9 times out of 10, that the board will go ahead and make a decision right then. They won't go, oh, we need to have people file briefs and do this more. What do you think? Because I think that it's going to get real complicated if it's like a standard thing for people to file briefs, and then we do want the Board of Appeals to make a decision, file a decision, and have that in writing. But we're asking people who have jobs, they're already going to take a day off to have this, of their job to have this hearing, and then if they don't make a decision, then they're going to be have these briefs, read the briefs, and then have to come back together and make a decision. So, see what I'm saying? I'm trying to figure out. I want it to be fair.
I wasn't thinking about the decision being talked out in public. And I don't know that there's any reason why it should be.
Well,
I'd
I think,
like to hear back on that. Yeah.
well, this reads to me like like a miniaturized Supreme Court, how
Yeah.
the Supreme Court would rule. And to me, just so it is in a written form that can be publicly accessed at any time, and more importantly, shall be reported to the West Virginia State Democratic Executive Committee ASAP. Next regular meeting being fine. Their reasoning is, if anything, perhaps it is more potentially damning for their reasoning to be in writing than for them to have to play it out live. And so I am kind of fine with this, just so the process is transparent, which all of this is.
but how do they get here's the problem. The rules of the party say that all meetings are public. Like unless there are very, very few times that you can have a private meeting that has to do with, strategy and personnel issues and stuff like that. Other than that, the party rules say Democratic Party rules are, I mean, meetings are open to the public. So how do you have a Board of Appeals deliberate in private? Now, what they could do is they could have do what, have a Google Doc, and they are kind of working out their written decision on a Google Doc or something like that. That's not a public meeting. I don't see anything wrong with that till they get to something that they like. But if they're going to sit in a room and talk about the outcome, to me, that has to be in a public meeting.
Let me, I think this was in the appeals procedure that the DNC had. So, and I don't think they talked about making those appeals decision in public. But I don't know. I'm going to try to look as soon as I can figure out.
All right, just so you guys know, we're over times, but we're almost to the end. So if we could hang in just for a few more minutes.
Sure. This was the original rules and bylaws that I worked from, which was for referred Alabama SDC challenges. Um, did not have this paragraph. It said it was a hearing officer shall make and file a written report to the RBC. So the hearing officer was making a written report in that one. But I didn't think we would be having hearing officers, so I changed that around. So I don't know. I mean, it would seem to me that a quasi judicial proceeding wouldn't necessarily have to be totally in public as long as the opinion is written and made available to the public. The actual deliberation wouldn't necessarily have to be in public, but I don't know. You're the expert on that, Selena.
Well, I think I tried to fix it all by saying, I mean, the fact of the matter is people do talk, and I mean, there's nothing around that. You know, a lot of decisions are made outside of the public, but if we have this, all decisions made by the Board of Appeals with respect to any issue pertaining to a grievance must be made by voting in a public meeting. So maybe there is some discussion that happens. Yeah, I mean, it would be great if there was just they had a hearing, there was deliberation, there was a vote, you know, and then that was followed up in writing.
Well,
But
back in 10, you could say that the Board of Appeals may reach a decision at the conclusion of after the conclusion of the hearing, the Board of Appeals may either reach a decision or set a briefing schedule for the parties.
okay,
And I agree with you. I think they would only set a briefing schedule if it's a very complicated case. You know,
Okay.
where both the facts are somewhat at issue and the parties would be trying to restate their version of the facts, as well as the rules being at issue.
okay,
And Selena, I think I think 12, I'm going through rule 63 again because I don't get to play through these very often. Robert sees coming to a decision in these issues as a vote. So the Board of Appeals will be voting on what their final decision is of essentially, does the challenger's challenge succeed, or is does the grievance succeed or fail? That's a vote. That should be a public vote. But Robert also talks about that the vote doesn't have to happen at the same time the evidence is presented. And it also, you don't have to report, they wouldn't have to give their logic on why they're voting that way. It's just a public vote in this case. So I think 12 solves 99% of the problems we have with everything here.
Right, and they could reconvene in the event that a briefing schedule has been set. Once the briefs have been so at some point after the briefs come in, they could reconvene to vote.
yes, yeah, and they could just do that quickly and in the evening or something like that. Yeah, by Zoom. All right, now this part right here, just go back to what you just said, Mac. That Robert says we don't have to have all that information. This says that we're saying that what comes out in writing has to have the finding of fact, the conclusion of law, which, you know, inclusion of law would be party rules to include which party rules are broken, whatever, and a disposition of the grievance, not just the disposition of the grievance. So do we want all that in there?
Yes, absolutely.
Yeah, I
Okay,
think
all right.
that's what-
Absolutely. Not even a question in my mind.
Okay, all
That's-
right. Just
That's
wanna
how
make sure.
you, that sets it up for review because you can determine whether the finding of facts are clearly wrong,
Yeah.
or conclusions of law are inaccurate.
Gotcha. Okay. All right. And they would have need time really, like, put all this stuff in writing, you know, especially if it's, unless you walk in from reading your briefing or your pleadings and it's just so blatantly obvious, you could go ahead and, try to have your resolution, written. But if it gets complicated, you need time to put all that stuff together. Okay, so I'm feeling happier about that. All right, now we're going to the argument. At the close of giving evidence to each side, the agreement shall be entitled to present oral arguments, generally not to exceed 15 minutes. Board of Appeals may require parties to consolidate their grievance or defense, and the oral argument shall take place immediately following the hearing. So, any thoughts on that? We good with that? That seems pretty straightforward.
Yeah, that seems pretty straightforward.
Okay.
Under burden of proof, where it says challenging, that should be grieving party.
Yeah. Yes. And I think that everybody okay with this by clear and convincing evidence? Okay. All right, now
That's a stronger standard than the old preponderance of the evidence, which is at least more likely, which is more likely than not. Clear and convincing means it's
clear and
it's
convincing.
yeah, it's clearer than more likely than not. So, but that's what was in this other. I think that I didn't add that.
Okay, yeah, that's good. All right. Now, so now we're down to the thing that we think we're all interested in figuring out. We all agree to this, and it's in the bylaws, that anybody that is not happy with the outcome of whatever the Board of Appeals does, they can then appeal it to the full state executive committee. But what is the process to do that? So we know that they have 30 days to do that. And this is the part that we put in pink up here, which I'm going to unpink now to make it a little bit easier to read. And then we can figure out how we want to do this. And then we're basically done for the evening. That didn't work.
Why don't you take that language and move it down to the appeals area, and we can.
For some reason, I can't get it to stop being
It's not letting you
pink.
cut. There you go.
Yeah, but I'm happy to see.
Let's put that in the
Oh,
end.
there we go. Okay. All right. So, all right. So either something has been dismissed, there's been a summary judgment, or there's been a hearing and decision. One of those has happened. How many, and people can appeal to the state executive committee. How many days, calendar days do they have? Are we suggesting that they have to do that? I think they need a little bit more than 5 to think about it, don't you?
Well,
I
what
think
was the
30 is
21 plus
okay.
10?
How about
That was for them. If I filed a challenge against you, you would have that amount. You would have 20, 21
Oh, okay.
or 31 to respond.
Okay.
appealable within 30 days.
30.
Yeah, it's got to be 30.
I think so too.
You can change that to appeal or review of appeal or review of Bob, get me a good word here.
Um, I,
I guess decision.
I think just appeal or review of the decision.
Okay,
And I guess that's paragraph 2.
Wouldn't that be better if you had review by the decision of the
Yeah.
Board of Appeals?
Maybe appeal
No,
for
I
review
like
by
that.
the WESDC. Or appeal to the WVSDEC.
so okay. This is really an appeal. I think we can take out review, don't you think?
Yeah,
Okay, so appeal of
Uh,
the
I would,
decision
this is just a title.
will to,
We
I
could-
know,
Appeal to the WVDESEC, SDEC,
okay,
and then just delete everything else in the title.
okay. So you don't want to, do we want to say of the decision of the Board of Appeals?
Nah, we don't need, I mean, that's what it's about. I don't
Okay.
think I think it's redundant.
Okay, all right.
Okay.
All right, so within 30 calendar days after service of a notice of entry of a dismissal or pleadings. So I think can I take out notice
That
of
should be
entry?
on notice of the entry of a decision.
Dismissal or decision, and then just take out
Oh,
on the
yeah,
pleading.
okay.
Yeah, take out on the pleadings.
Dismissal or decision, just take out on the plea. It's good, Mike, Mac.
Okay. An aggrieved party may file a petition for review. Well, it wouldn't, or petition for appeal, right?
Just say, well,
Yeah, yeah.
okay,
For appeal with the WSDEC stating objections to the Board of Appeals action and may file a brief within 30 calendar days. Well,
yeah, I
do-
think 30 is good.
another party may file a brief. Okay.
That puts you 60 days
Yeah,
out
it does.
state
It's
hearing it.
slow. It's slow.
Do we want to change this to like 15 or 14?
14 sounds lovely.
14 calendar days after the service of a petition, any other party may file a brief. The SDC shall also have authority to make a decision on the pleadings where it is plain from the challenge and answer. Together with documents come in those pleadings that there is no genuine issue of material fact between the parties.
I think that's language that's left over from the old dismissal.
Yeah,
Okay.
that can come out.
And
So delete all this right here.
I would say the WVSDEC shall have the authority to make a decision on the record and before the Board of Appeals.
What do you mean before the?
Before. We haven't used BOA anywhere else, although
I know, I'm just doing it for
okay.
Shorthand.
these purposes. Yeah. I don't understand what that means.
What?
The SDC shall also have authority to make decision on the record before.
That
the
would be the documents and the recording of the hearing.
But
You could
I
say
mean,
that instead of record if you want to.
why are we putting that in there? Because we know that they have the authority to do it. The bylaws say that they have the authority.
Well, this is part of the rules for the Board of Appeals.
I'm okay with striking all of that, really. I mean, for me, the big thing is we know they can review it. They have the power to review it. If they have the power to review it, they should have the ability to take any action necessary to review it. The question is what is the timeline? We've established how someone goes about appealing. I guess the idea would be what happens once they make that appeal, which is the example language I have on the side.
So I think Mac's right. We should delete the entire rest of that paragraph.
Okay.
I think that's what he was saying too. And then how the WVSDC, how the executive committee handles it is something that needs to go in the bylaws and not in these rules. These rules just cover how it gets to the Board of Appeals and how it leaves it and how it's evaluated and what you do to get out to go to the next step if you need to.
I am fine with that argument if we set that as our next topic of discussion at our next meeting.
Yeah, I think we should.
I'll quid
Because
pro.
I think that's gonna be interesting too.
Well,
but-
we got a couple other things. I don't know. I don't know that we should do that at our next meeting, but I think that we should do it because we still have the count. We focused on councils, and there's a couple other things that I think we need to wrap up. But we've wanted to get back to Board of Appeals. So could we come back to? Would it be okay to just get back to the Board of Appeals soon?
I hate this topic. Fine. I'm really
here's the thing. Hold on just a second. I need to tell my mom something. Let me put you on mute for a second.
While Selena's on mute,
Okay,
Bob,
go ahead.
there is something else that we have to talk about after this, which is if the Board of Appeals is the challenged group.
Yeah. There's something else on that too I had to add, but that'll wait till a future time.
Anyway, Selena's back, so.
Okay. All right. Well, I want to look at this language that you put in, although I don't see it right now.
It is in the comments on the other side, to that very paragraph. So if you click
here?
on,
I
go
think when I
down.
deleted something.
Oh gosh. Yeah, above that group right there is what you're looking for.
Oh, okay. All right. Okay. So there needs to be an effect there. Okay. Why don't, instead of me just reading it, why don't you kind of read it and explain what you mean by this?
Essentially it's saying that the language for the appeal process needs to have a statement of what that process looks like, the effect thereof of appealing, and which we have added. And then a respond thereto section, which is what happens next, which we have agreed goes into the bylaws, and we will talk about it at a later date. And what should happen if the executive committee chooses to not respond to an appeal. But again, that is all bylaws stuff that we've discussed. So, but I've got a template for that if anyone wants to. It's in the comment there on the right.
It's
Well,
now in
I
the
just
body.
plopped it down. I was able to find it.
Oh,
and copy it,
okay.
so
I was inside the document reading it. I didn't notice that. I'm sorry.
No, it's okay. You're fine.
I think that's bylaw material, like Max said.
Mm-hmm.
Oh, definitely. I'm willing to concede that.
Okay. All right. So,
How did you want to incorporate those general rules?
okay, well, give me just 1 second. So is this, are we good on the, wait, this is close enough to just be able to wrap up how to appeal to the SDC? They file a petition to appeal is based within such and such time. Or are the dates that we have, does that go into, should that be bylaw things too? I'm kind of thinking it is.
Porque no los dos. Why not have it here and there?
Yeah, I think that's good.
Well, here's the problem. I don't think that we can make decisions for the state executive committee. Any decision, like any of our bylaws that we write, goes to them to get approved. We're not even approving these. We are recommending these for the Board of Appeals, who will then adopt it. I don't think they can adopt and make decisions for the state executive committee.
And they may want to change them a little bit too before they adopt them.
Yeah, I have a feeling
Well,
that they will.
Well, the idea is that we will eventually adopt this language and they'll be forced to cope with it, or language similar to it. So
Yeah,
it's
but
kind of just plopping it down for when they're there, when we do adopt it.
Yeah, but just because when you say we, do you mean RBC or we, the state executive committee?
RBC and then by extension, the state executive committee, because
Yeah,
we have bylaws change.
Yeah, but we got to have 2/3 of the state executive committee to adopt it. So I would assume that they would, but I mean,
Yeah, I would assume that no assembly being given more power would hereby turn down that power.
I get, okay, but here's the thing. If we leave it in here and we say within 30 days after service, you have to file a petition of appeal. Let's say the Board of Appeals adopts that. And then at 35 days, somebody files an appeal. And I mean, those, the rules are not for the state executive committee, have not been adopted by the state executive committee. So they would be right. I mean, I think that we're right. I just don't think that we have the authority, or even the Board of Appeals has the authority to put a time limit on the appeal. I think only the state executive committee can do that.
The reason to have it in these rules is that it explains the time to the litigants. So something should be in here to tell them what period of time they have. And I think that if the executive committee decides that it should be more or less time, then the appeals board will have to modify it, whatever rules it adopts.
So you want to leave the numbers in there?
I think so. I think it's important to have a definite period of time for that appeal.
All right.
It can always get changed later by them. To
Okay.
comport
Yeah, I agree.
whatever
All right.
comes from the DEC.
All right. Is there any? All right. So Mac and Bob agree. I don't agree, but that's okay. Anybody else want to weigh in on this? If not, we're just gonna move on.
I agree with them because if you don't put some time limits on there, it could almost be indefinite when they could file it.
Okay. All right. Hearing nobody else, I'm going to go on. Okay. So the general rules, I'm not exactly sure where I mean, I just think one of these lettered, areas, section here towards the beginning to just say, like, here's some general rules, and to have them actually be full paragraphs to say, all documentation that submitted needs to have page numbers and needs to have numbered paragraphs, and then something about electronic copies are okay, so that people don't have to make, 5 copies of, the charter and the bylaws or whatever, you know what I mean? That it is acceptable to use electronic means and to share documents. Those are the general rules that I thought about. I don't know if there's any others, but that was my initial reasoning behind that. I can kind of turn that into, if you guys are agreeable, I can turn those into like real paragraphs.
I'm fine with that.
Works for me.
Same.
I got Deb's thumb up. Okay. All right. That sounds good. Anything else? Any other comments from anybody before
Oh,
we?
yes, that purple section.
Okay.
And
Yeah, this is what
that's
we moved
deleted.
down.
Okay.
Yeah. Let me just,
All right.
yeah. We deleted that. Who said that? Oh, Nikki said she's happy. Yay.
Bob and I, or a few of us, were talking while you were gone, Selena, about what should happen should the Board of Appeals be the challenged group.
If that were the case, it seems to me like the chair would have to appoint a special Board of Appeals to handle it.
Or
That
does
sounds
it go?
like a,
Yeah.
ahead.
Probably also bylaws material.
Fair.
yeah.
Definitely okay
I-
punning that.
I hadn't really thought about that. Okay. All right. Remember that point when we get to the bylaw section.
Yeah. I guess it could come up if somebody grieves about the Board of Appeals not following their rules.
Well, there was a time that I wish I could have made that.
I- That might
Yeah.
be on appeal anyway.
Or maybe even, what if a member of the Board of Appeals is a person included in a grievance? Yeah.
Yeah.
Stuff that's really nitty gritty stuff that we talk about as parliamentarians. So
Mhm.
Yeah. I
Okay.
think it's still bylaws material, but
Yeah. Okay.
it's gonna be a
Well,
long.
it's yeah, good. I mean, it's good fodder for thought. Okay. So I think I'm going to stop sharing for a minute. I think this is, I have to tell you, I'm so happy that that we did this. I think this is a really good and fair process for them to work. I think it adds it just really adds to the fairness and the openness and transparency that we have all been dedicated to doing. So we will take this document, I'll clean it up, I'll pass that on for the staff to look at, because there's some stuff they need to
Do
do.
we
And then,
need
yes,
do we need a motion to recommend it to the Board of Appeals?
I don't think we need it, but I don't think it would hurt to have it.
I'll make
Just to
that
sort of
motion.
cover our bases. I think that's fine. You want to make a motion, Bob?
I'll make the motion that we recommend these rules of procedure of the Board of Appeals to the Board of Appeals for their use. Once it's cleaned up.
All right. Is there a second?
I second it.
Any discussion? All right. Hearing none. All in favor of Bob's motion to clean this up and get it to the Board of Appeals for their consideration, please indicate by saying aye.
Aye.
I
Any opposed, please indicate by saying nay. Okay. Motion adopted. Thank you. All right, guys. Let's put on our calendar for February whatever the second Tuesday is in February, which is February 13th. Please mark that on your calendar, 6:30 for our next meeting. And I'll send you guys, when I get this cleaned up, I'll send you guys copy and I'll just mark big draft across it. So you guys will have it as well. And so thank you all for all this work. Bob, you took on the lion's share of this. Thank you so much for doing that. All right, well, this was kind of fun. I enjoyed this meeting a lot. Okay.
Okay,
So,
I move we adjourn.
yeah, Corey, thank you so much for being on and helping us with all the technical behind the scenes stuff. And if there's nothing else, I think that we can go ahead, since we finished our agenda, we can go ahead and adjourn. So good night, everybody. I appreciate you very much.